Peace, love, and light. I am Picasso Cognizance. This is Resolute Fathers. Make sure you like, subscribe, and tell a friend to tell a friend about Resolute Fathers. And make sure you get the copy of Who's the Daddy. It is on Amazon. Now, according to LegalMatch.com, what is child support arrears? According to the definition in the glossary of child support complied by the state of Arizona, child support arrears refers to the total unpaid support obligation owed by a person under a court order to pay support. A court-ordered arrears is the total amount past due in owing under a court order. Keep in mind that there is a distinction between state and court-ordered child support orders. For instance, state-assigned arrears refer to the total amount of support past due in owing under a court order assigned to the state. They are generally temporarily assigned, permanently assigned, and unassigned in current and past public assistance cases and never assigned arrears in current non-public assistance cases. Arrears, judgment, court-ordered payments refer to the past due and owing for a specific time that has been reduced to a written money judgment. When is child support ordered? Depending on your state, child support can be ordered for several reasons. For instance, in Minnesota, if a married couple with minor children is divorced or has a legal separation, a court must enter a support order against one or both parents. If a married couple with minor children lives apart, one parent or the public authority may ask the court to seek a support order against the other parent. If a child is born to parents who are not married to each other, paternity must be established first before a court can order a child support order. And paternity can be established by court order or by the parents voluntarily executing a document known as the recognition of parentage. Check your local state for similar forms. In most cases where paternity is not contested, establishing paternity is usually simple. However, if paternity is contested or involves multiple parties, establishing paternity can be challenging. For example, some courts may order an alleged father to pay temporary child support if genetic tests indicate a likelihood of paternity of 92% or greater. Furthermore, if a child is in the custody of an entity or individual other than a parent, either by court order or paternal consent, a support order can be granted against the parents in favor of the individual or entity who possesses custody. What are the basics of child support guidelines? Child support orders are legal obligations to provide financial support for a child or children and are established by the court of law. For instance, all child support obligations in Indiana are governed by the Indiana Child Support Rules and Guidelines issued by the Indiana Supreme Court. The guidelines adhere to a methodology designed to calculate child support as the share of each parent's income is estimated to have been spent on the child if the parents and child were residing in an intact household. For the non-custodial parent, the calculated amount determines the amount of child support to be paid to the custodial parent for the benefit of the children. The amount calculated for the custodial party is assumed to be spent directly on the child or children. You hear that, custodial parents? Okay, so be mindful of that. Don't get caught up in your emotions and feelings and thinking that child support money that's meant to be for your child, you spending it on yourself, buying whatever. The guidelines specify special considerations for extraordinary education expenses and visitation. When a child reaches 18 or 19 years old, the child is emancipated by the operation of law, and the non-custodial parent's obligation to pay current child support terminates. But an exception is if the child is considered incapacitated. In these circumstances, child support continues during the incapacity or until further order of the court. A court order for the child support to extend beyond the mature ages is required. The court shall emancipate a child before the age of 18 or 19 if the court discovers that the child marries, enrolls in active duty status with U.S. military, and the child is not under the care or control of either parent, an individual, or an agency approved by the court. Furthermore, the court may eliminate a non-custodial parent's support obligation with or without emancipating the child if the court declares that all of the following circumstances exist. The child is at least 18 years old. The child has not attended a secondary school or post-secondary educational institution for the prior 4 months, is not enrolled in a secondary school or post-secondary educational institution. The child is or is capable of supporting themselves through employment. If a non-custodial parent owes any arrearage at the point when the order for child support terminates, they are still obligated to pay the arrearages. If a child support order covers 2 or more children and one child is emancipated, the amount of child support will not automatically be reduced. The parties must request a court order modification to determine the new amount of support for the remaining child or children. So that's why I say do not get the system involved, family. Take care of your own responsibility. Okay? Now, for unfit parents, this is what we have to be mindful of. And this is when the system should and shall be involved in any type of situation like this. Okay, the legal definition of an unfit parent is when the parent, through their conduct, fails to provide proper guidance, care, or support. Also, if there is abuse, neglect, or substance abuse issues, that parent will be deemed unfit. That's when you get the system involved, child support and the whole nine. You feel me? But this channel right here promotes fit parenting. It shouldn't be no reason for the system to be involved in this type of situation. So just make sure you like, subscribe, and make sure you get that copy of the book, Who's the Daddy? I'm telling you, you will learn something. You feel me? Like this, hey, spread this channel, family, and tell a friend to tell a friend about Resolute Fathers Patreon. If you want to know how to do a modification, you know how to write an affidavit. I mean, the list goes on. Make sure you join that as well. All right? Peace, love, and light.